Okay, hello everybody. Welcome to our Secure Act webinar. We have a significant number of attendees here today. I know that the uncertainty in the world with the coronavirus can be very unsettling for a lot of folks. And I hope that today's webinar is a good opportunity for the attendees to focus their attention on something positive, like retirement and estate planning. With the current state of financial markets and the quarantine procedures in effect, I think it's an opportune time to have conversations around these topics, regardless of age or status. I'm also super excited that we have Dana Sipple and Lauren Jenkins joining me today. Dana is the Vice President of Glassman Wealth and regularly speaks on these types of topics. His firm is very well known and respected in the industry. Lauren is a principal at Offutt Kerman, and she is one of the regularly celebrated top trust and estate attorneys in the DMV area. She also has some fantastic articles on her online firm profile. So if you have some time, and I know we all do, I especially like her mini guidebook for irrevocable trusts in Virginia, and would advise folks to check that out. A couple of housekeeping notes to start. First, we have a Q&A box. So if you have questions, please send them to us through that box. We will reserve some time at the end to address some of these questions during the webinar. Any questions that are not addressed, we will follow up with you via email. Second, the webinar will be recorded and sent to you via a secure link, so you'll be able to look at it again if you want to. Third, you're going to get a PDF of all three of our slide decks. So I'll present first, then it'll be Dana, then it'll be Lauren. You'll get 3 different slide decks, though, in PDF format in the coming days. And for future webinars, we'd like to hear from you on suggested topics. You can send those suggestions to info@thewolfgroup.com. And then lastly, I know a lot of folks may have questions on the economic stimulus pending legislation in the Senate and how that relates to the 2019 tax return filing deadline and payment deadlines. Briefly, what I can tell you is that we do know that the federal payment deadline has been pushed back 3 months. That is the only confirmed thing that we know at this point in time. And we also know that California is the only state that has pushed back their filing and payment deadlines to June 30th. There are rumors about other changes to perhaps the filing deadline of April 15th for Fed and some of the state jurisdictions as well. Again, nothing is confirmed or specific, but once we do know more, the Wolf Group will either send out a tax alert or we'll do maybe a mini webinar where I will go over some of the specifics, and I promise that as soon as we know this information, you will as well too. Just a quick intro on me. My name is Mishkin Santa. I'm the International Tax Director here at the Wolf Group. This is a little bit about my background. Formerly with the Internal Revenue Service after I got my L at Boston University. Been in private practice, ever since. Got 14 years of experience, and the director of the Wolf Group for compliance and consulting. For today, for my presentation, I'm going to be speaking on tax aspects of the Secure Act. I'm going to go through how it applies to individuals. I'm going to talk about something that's really significant for those folks that have foreign retirement plans. It's kind of a complete change to IRS policy and how we classify and report foreign retirement plans. I'm also going to talk about how those plans are kind of coming in alignment with U.S. retirement plans. And then lastly, I'm going to briefly run through some aspects of the Secure Act as it applies to businesses. Okay, so the first thing to note for the Secure Act is that it changes the age for required minimum distributions. And this makes sense, right? I mean, people are living longer than they did a generation ago. And so for those folks that are turning 70 and a half years old in calendar year 2020, that the age is now 72 years old for required minimum distributions, which now allows more people to grow their plans if they want to or consider Roth IRA conversions. You also have the opportunity to do perhaps some charitable planning, and I know Dana is going to talk about that within his presentation as well. For expatriates offshore, we've recently seen a slew of these come through the Wolf Group, and then we see them regularly at the end of every year where we have, and when I say expatriate, I'm meaning an individual that may have given up their green card or their citizenship, but they still have what we call eligible deferred compensation, which are U.S. retirement plans, IRAs and 401ks. and they're trying to figure out, okay, I'm coming up on the RMD age, I'm going to be forced to make a distribution. How does that distribution work for me as an expatriate? What are some things to consider? Does the tax treaty apply to me? Do I have time to plan this for both the US and my foreign jurisdiction? So there are a lot of moving parts there when it comes to required minimum distributions for expatriates. And I can tell you that in specific with the treaties, there's a very specific clause within the treaties that is the savings clause that you need to look at for distributions from US retirement plans and how that works specifically with the pension clauses. Inherited IRAs. So this is a big one. In order to raise revenue, the Secure Act does away with the inherited IRA provisions that were previously in place. The goal was to capture about $15.7 billion in additional tax revenue. That's, if you read the legislative history of the Secure Act, that's kind of what they were trying to do by getting rid of the stretch provisions. And you know, when I think about this, I think about actually my son who's now almost 4 years old. Back when he was 2, he actually got an IRA from his great-grandfather, and he's able to stretch out payments from that IRA over the course of his life. But if he had got that IRA, say, in calendar year 2020, there are no provisions for great-grandchildren. If you look at the bottom there, the exceptions are surviving spouse, minor child, disabled person. There are no exceptions for great-grandchild, so he would have had to fully withdraw the plan within 10 years instead of being able to take a small amount over the course of his lifetime. So that's a huge, huge change. For non-resident aliens, this is also something that we see a lot of, and we see this in 2 cases. We see, you know, people in the United States that have relatives that are non-U.S. people, and the U.S. person who has the IRA passes away, and their next of kin happens to be a non-resident alien. And so the question is, how do those inherited IRA provisions, you know, apply to a non-resident alien? And then another iteration that we always see would be a U.S. person that has moved to a foreign country but had a U.S. retirement plan before they moved. They then pass away, and then that retirement plan goes to a non-resident alien beneficiary. And there are different considerations between those 2 iterations, because the person that is in the United States that passes away mostly will have all U.S. source income, whereas the person that has moved outside the United States will need to make allocations between U.S. source income and non-U.S. source income. The beneficiary, when they start to take distributions, will have to report those distributions as effectively connected income, and then make an argument under one of those 2 iterations using the treaty and showing the IRS how they want to bifurcate U.S. versus non-U.S. source income. So there's a lot to walk through when you have an inherited IRA with a non-resident alien, and now that we have the stretch provisions that are gone, we'll have to look closer at how we deal with those from an income tax perspective. Retirement plan contributions. So this one was a big one. One of the statistics that I think popped out to me from the Secure Act when you review the legislative history is that the U.S. Bureau of Labor Statistics took a poll, and they did a survey, and they realized that only about 55% of the adult population participates in workplace retirement plans. Even more so, the median average balance of a 401k for those folks that are 65 or older is right around $58,000, whereas the suggested balance for people between 30 to 39 years of age is $66,000. So you can see that we don't have enough people participating in workplace retirement plans. We also don't have enough people contributing the proper amounts to retirement plans in general. So as part of the Secure Act, they're allowing folks that are older and continuing to work to now be able to contribute to those plans as long as they're still working after the age of 70 and a half. And this aligns more with traditional IRAs and Roth IRAs. One big question that I'm asked by a lot of people that are my age, that, you know, we're into our 2nd child now, and we have a lot of friends and family that are having their 2nd children as well, is about this qualified adoption and birth expenses, the withdrawal of $5,000 penalty-free from an IRA. I've been asked this a couple times, and again, the provision is here to help with medical expenses for the birth of a new child or the adoption expenses for a qualified adoption. You can withdraw $5,000. So if you have 2 parents and each parent has a 401k or an IRA, each parent can withdraw $5,000 penalty-free. So there's no 10% early withdrawal penalty. So a total of $10,000 can be taken to pay for those expenses. And if you pay it back as a rollover contribution to a new IRA, you actually pay no tax on it. So this is a very big win for people that perhaps are in a situation where they have significant medical expenses for a new birth or significant expenses for a qualified adoption in calendar year 2020. 529 plans. I know that one of the big things that was holding up the Secure Act was Ted Cruz. He really wanted to have 529 plans pay for a lot of different things. The one thing that actually got through here was using a 529 plan if you have money left over to pay for student loan debt. So if for some reason you have a child that has a 529 plan, you've used some of the plan to pay for their college or their secondary education, and you have some left over, and that student then has maybe some student loan debt also associated with that, you can then use part of the 529 plan to pay off that student loan debt. You can also use the 529 plan to pay for apprentice programs. I'm not really sure what that applies to, but looking forward to seeing regulations and how they define exactly what those programs are. The kiddie tax, this one came in, and a lot of people will miss this, but if you look at the Secure Act, it has 30 different provisions and basically sailed through the House very easily. It got stuck in the Senate because basically the Senate wanted to attach the tax extenders bill to it. And that's what took it a little bit longer than usual to get through. And one of the tax extenders that they wanted to get through was the kiddie tax. They changed the kiddie tax with the Tax Cuts and Jobs Act to use trust rates instead of parents' rates. And so they've kind of flip-flopped back to the old law where they're now allowing folks to use the parents' rates. You can actually go back and amend your 2018 return if you determine that the trust rates were actually not as beneficial as the parents' rates if you have kiddie tax implications on that return. Itemized deductions. So this is another item that got through on the tax extenders portion of the Secure Act. And so we saw that the medical threshold for itemized deductions dropped from 10% to 7.5% for 2018. It was supposed to revert back to 10% for 2019. The Secure Act gives a two-year extension on that, so we'll stay at 7.5% for tax years 2019 and 2020. The tuition and fees deduction, so this one expired in 2017 and was not renewed under the Tax Cuts and Jobs Act and was not part of an extender package. They've allowed this now to come back in retroactively for 2018. So this is another one that if you had tuition and fees deductions that you weren't able to take in calendar year 2018, if you want to go back and amend your tax return to include those, you can definitely do so. But this one will now be good until 2021. Foreign retirement plans. I'm going to go a little quick here because I'm running up to my time limit, but foreign retirement plans, for a lot of folks that don't know, the Secure Act is silent on this. And in general, the treatment of foreign retirement plans falls under certain sections, similar sections of the Internal Revenue Code as U.S. retirement plans. This is one of the areas where the IRS kind of gets a black eye because the guidance is not very clear, and you're dealing with non-qualified exempt trusts rules under 402, and then foreign grantor trust rules under 679. And so it's been quite complicated for the last, I would say, 11 years since Internal Revenue Code 6048 came into play. One of the big wins, though, that we recently got from the IRS, it was recently just published on March 16th, is the RevProc 2020-17, which basically allows for offshore pensions to be what we call tax favored if they meet certain requirements. So there's an annual contribution limit, a lifetime contribution limit, early withdrawals and distribution conditions, and then in-country rollovers don't seem to take the plan out of tax favored status. So that's a huge, huge win. Before I go on, though, let's go ahead and get to our first poll. Okay, so the first poll is, what is the required minimum distribution for individual retirement accounts under the Secure Act? And looks like we've got just about everyone answering 72. We've got a couple people at 70.5, some are saying 65, and yes, okay. So the majority of folks answered 72, and that is the correct answer for this poll. Okay, moving on. The next part of RevProc 2017 is for what we call retirement savings plans. This one's a little odd to me because the plans have to have specific conditions that say that they're for medical, disability, or educational benefits. My big problem with this is that a lot of foreign jurisdictions, all three of those items are paid for through the government. So they're basically free to taxpayers in most foreign jurisdictions. I very rarely, if ever, have seen any foreign non-retirement savings plans be conditioned on medical, disability, or educational benefits. Although this is an opportunity, I think, for a lot of offshore brokers who are looking to set up these types of plans to perhaps rewrite their documents to meet the requirements of the safe harbor under 5.04 of RevProc 2017. Lastly, another big one here is if you received a penalty for Form 3520 or 3520A for a foreign pension reported or classified as a foreign grantor trust, and you do meet the requirements of 5.03 or 5.04, which I just talked about, you can actually get the IRS to refund the money back to you. Believe it or not, they're going to give the money back to you. You do have to complete a form. It's called Form 843, and you have to attach an explanation with documentation showing how you qualify. We have actually done this for several of our clients, and if you need help with this, please let me know. Happy to get this paperwork done for you. It's pretty straightforward. And then recently, we've seen a lot of foreign pensions be converted to foreign annuities, which is something that the Secure Act actually is also coinciding. They're letting 401ks, in the past, I will say you could have done it in the past, but it was really difficult from a regulatory perspective. Now it's a lot easier to have an annuity plan connected to your retirement plan here in the United States. So that's always a good thing. I'm going to run through very, very quickly the tax aspects for businesses because I'm already 2 minutes over on my allocated time. But basically, if you think about the plan, the Secure Act is trying to get more people to engage in retirement plans. They're letting people that are part-time employees qualify easier for retirement plans. I think if you look at the legislation, they estimated that only 33% of part-time employees were actually able to participate in employer retirement plans. So it's a big thing that we allow more people to participate in retirement plans within their employers. So there's these small business owner credits, the multiple employer plan. So it's allowing small business employers to kind of quote unquote band together to offer a retirement plan and make it easier to give their employees plans. And then lastly, there's all sorts of additional related items that kind of help small business employers, offer those retirement plans. But with that comes very high penalties for not following through by the employers. So you have to be very, very careful if you're offering those plans. That's all my time. I'm going to go ahead and turn it now over to Dana and let him talk about his portion of the presentation. Thank you.
Good afternoon, everybody. This is Dana Sipple here, and I am happy to be here with you guys in terms of today. Great to be able to share this kind of information on a day where we're all kind of holed up at home or under some crazy circumstances. But I want to thank Michigan for going through a lot of those tax options there. And certainly what I want to do is dive into a little more detail on the 10-year rule and certainly some planning strategies that we may have in terms of wealth planning on these items at this point. So let me move on here now and give you a little bit of an introduction to me. Dana Sipple, I'm a financial planner, wealth manager here at Glassman Wealth Services. I've been doing this for over 25 years and certainly really enjoy working with my clients on strategic planning that both involves investing, financial planning, and also the tax strategies and how we meld that all together to get clients good results on the overall outcome. So let's talk a little about that Secure Act 10-year rule. Michigan mentioned this, and essentially I just wanted to add to this a little bit that, this was really something that was the second tax act, the major one that was signed here in the last couple of years. So it's really kept taxpayers scrambling. But as he mentioned, effectively this is limiting IRA stretches to 10 years now rather than lifetimes.
Dana, excuse me, this is Lori. Can you share your presentation?
Oh, sorry, is it not being shared?
Yep,
My apologies.
No problem, thanks.
Is it up now?
It's up, just go in slideshow full screen mode.
My apologies. Sorry, folks.
Thank you.
Moving on from that. So continuing on now, Michigan mentioned some of these exceptions for beneficiaries. The only things I wanted to add on this is that really the old rules apply to most of these situations here. So I think that Lauren's also going to talk a little more about it. So I'm going to skip over this and not talk too much detail here. But what I'd like to do now is do a quick poll here. And the poll that I have here is, question would be, would your heirs likely spend an inherited IRA in 10 years or less? The answer would be yes or no. And I see the majority of people are coming up with no on the poll, so that's good because that's what we're going to be talking about today and some strategies to work around that. So we'll go ahead and move on from that here, and I want to flip to my next screen here. And we'll move on and take a look at this. So what I want to show you on this screen here is essentially $1 million IRA that's inherited under today's rules versus what they were prior to the Secure Act. So you've got periods of time here, and this does tax and actually inflation, growth affected, and you can see 10, 20, 30-year periods. And what you want to be taking a look at here is that for someone to inherit an IRA under the old rules, you can see when you get out to 30 or 40 years, which would not be unusual, you can see that it can make $1 million to $1.5 million difference in terms of that net. So what we're looking at is, what we're going to look at here is options to be able to extend that out and working within the 10-year window that we have going these days. So let's talk about some of the solutions we're going to look at today. I'm going to concentrate on these first two, the new spousal rollover trap and Roth conversions. We may come back and talk a little more about IRA trust for state income tax savings. Qualified charitable distributions is also an option that you can use to deplete or certainly take distributions out of the IRA. I'm going to come back and talk about IRAs to charitable remainder trust and some life insurance solutions. And then Lauren's going to talk about some of the trust issues. So let's look at this one, the spousal rollover trap. This is one where it was almost a no-brainer in the past that if someone passed away, you would almost always roll the IRA over to the spouse. That would almost always make sense. However, for now, it may start to make sense, especially for people with larger estates, to be able to take some of that IRA and possibly bypass the spouse, move that directly on to the beneficiaries or the children in most cases. Let me show you a little more about how this might work in a graphical form. So you see here on this slide where we show the deceased spouse, and normally the line underneath, we would have gone to the surviving spouse, and that would work effectively. And then when she passed, let's just say it was grandma and grandpa, when grandma passed then, she would then pass it on to the kids. And it didn't really matter because they would still get a lifetime stretch. Now it may make sense under these more compressed rules for some or even all of, let's say, grandpa's, he's the first one to pass, his IRA to go on to the children. And let me move on to another slide that'll show you a little more how this might work. So again, we're using grandpa and grandpa here, grandpa and grandma. The first death, grandpa dies, and instead of rolling it all over to the spouse, he gives some or all of it to the kids, and they immediately start taking that 10-year distribution. Let's assume that grandma lives 8 more years. At that time, she passes away, and then her children then get 10 years to take distributions out of her IRA. So what we've done is effectively converted under that situation from 10 years to 18 years. And obviously, we could have up to 20 years. So what we're doing here is we're able to spread these distributions out and hopefully have them taxed at lower brackets, give more flexibility on the planning there. So this is a spousal rollover trap that we're going to want to avoid. Now here on the Roth conversions, the next angle we're going to want to go to, and essentially what we're going to be talking about in Roth conversions is being able to spread distributions out over many years and be able to reduce those distributions to the ultimate beneficiary beneficiary or whoever's going to get that into lower brackets. That's what we're going to be focused on. There's several issues here that are going to make this more conducive to somebody taking these distributions. Certainly taxpayers that have special favorable tax attributes, charitable deduction carry forwards, tax credits, net operating losses, high basis, non-deductible IRAs, are going to be much more favorable for those folks. The also people that will be more favorable are ones that are expecting large required minimum distributions when they do get to age 72 and beyond, because that could bump them up into higher ordinary tax rates, capital gains rates that are higher, Medicare premiums that get kicked into a higher rate. Some other things that are worth considering: the surviving spouse will require large distribution for living expenses. We'll talk in a minute here. I'm going to show you a chart that shows how much higher these single tax brackets are, and that's what you would be for a widower than they are for a joint couple. So you're not going to want to have to take a lot out at that time if you can avoid it. Beneficiaries here that have higher tax rates. A lot of this is family planning also. You look at the parents' generation, and if they're in a, let's say, grandma and grandpa are in a lower tax state, they live in Florida, they're only the 22, 24% federal tax rate. Their kids are doctors or attorneys or some other high-paying profession, and they live up in New York City and they're paying over 50% taxes. So what you'll be looking at is, does it make sense for the grandparents to convert and pay at a lower rate than pass on a tax-free benefit? And of course, someone that owes estate tax is going to make a lot of sense, because that will allow them to convert, pay some of those taxes, lower their estate. So let's look at this in a little more detail. General Roth IRA concepts. A couple things we want to consider. 100% of growth in a Roth IRA is tax exempt. No required distributions for anybody during their period of ownership, during the original owner. There are required minimum distributions on the inherited Roth IRA, but in most cases are going to be tax-free distributions. Let's talk about a couple provisions on the taxation of Roth IRA distribution. So you've got some red boxes and some yellow and green here. What you're going to want to be able to do is get to the green boxes. And essentially, this is for someone who's making a Roth conversion but may end up want to make sure that they have the flexibility if they needed to come back and take it out of this Roth. So two key factors, one being over the age of 59 and a half. That's going to be one tick box to get you the green. The other is having the Roth IRA open for at least 5 years before distributions begin. So one way you can get this time clock going for a couple, what we're doing is having people open a Roth IRA account at a younger age, maybe 40s, 50s, long before they want to do this. You can fund it with a de minimis amount of money, and that will get your time clock going. Then you're going to be in that green box. Let's move on here and talk about the eligible accounts for Roth IRA conversions. So essentially, almost all qualified retirement plans will be eligible to do Roth IRA conversions. Now, when you take something like a 401k or profit sharing plan, some of those accounts might first have to be rolled to an IRA, a traditional IRA, where they can then be converted. So it may be a two-step process, but other ones will be able to directly be rolled. Now, I want to point out here, there are a couple of plans here, 403B annuity plans or 457 plans. The actual 10-year stretch rules don't begin until January 2022. So if you have someone with that type of plan, you want to make sure you don't make the planning mistake of not using the stretch provisions under those plans right there. A couple other non-convertible accounts, inherited IRAs or educational IRAs. So the mathematics of a Roth IRA conversion, the critical decision factors here that we're going to be looking at to see if this makes sense would be the tax rate differential, the year of conversion versus the withdrawal years. We want to be using those lower tax rates. Also, the fact that if somebody has funds that are outside of the IRA that they can use to pay the taxes, that'll be helpful. If you have to take additional funds out of your IRA to pay the tax, it doesn't work as effectively. Whether they're going to need the IRA funds to meet living expenses would also be an issue. If they need a lot of those funds, then it may not make as much sense to do Roth conversions. And then time horizon. Of course, a longer time horizon is going to weigh in your favor. So let's take a look here at tax rates here. This is important. If you focus on the right side of the slide, the married filing jointly, you can see that the 22 and the 24% brackets go all the way up to $326,000 of taxable income. That's going to be key. It's because you can convert at these rates or lower, then it really makes more sense. Let's show you here how this stacks up against where the rates were prior to the change in the tax laws a couple of years ago, 2017. Let's focus on the middle column here, which is 2020 married filing jointly. And you can see here how the 24% bracket goes all the way up to $326,000 of income. So that's a pretty good amount that you can get without paying these higher rates. If you look over there to 2017, you can see how that compares. You'd be well into the 28 and 33% bracket prior at these rates. And then the other one is when someone becomes single or a widower after their spouse has died, you can see the 24% rate is at a much lower amount, 160,000 or so, versus the extra amount that we move up to 326,000. So we're going to want to be working on those conversions while there's still a couple, and rather than when there's a widow or a widower. This just really kind of walks you through this on the steps, so you can see really the target bracket is going to be this 24, 22% bracket, or below is where we're going to be targeting for these Roth conversions. So the key to coming into these Roth conversions is really in terms of where we're going to want to end up. Successfully is going to be usually avoiding exposure to the higher marginal rates. And that can be either within the couple's planning strategy or looking at their beneficiaries and where they might end up with that also. So a couple other strategies here. The charitable remainder trust is one that's worth taking a look at. And this is only going to be for someone who is charitably inclined, not going to be something that makes any sense for somebody that doesn't have a very strong charitable inclination. So what you would do here on an IRA, so what you would do is your IRA the required distributions would go directly to a charitable trust. No taxation since it's a charitable organization. At that point, inside the charity, you would have the opportunity, or the payments will come out to your beneficiaries, presumably kids, over their life for up to 20 years. Those payments will be ordinary income. Some of them could be converted to capital gains if you have the ability to get some growth on that. However, it's important to note that at the end of the trust term, those assets that are remaining in the trust do go on to the charity. So there has to be a strong inclination for charitable, because there's a portion that's going to the kids and there's a portion that's going to charity. Here's a graphic that shows you the net to the family and charity. You can see by the green bar there, that is the stretch IRA, and those rules are no longer in effect. So then if you go over to the orange bar, you can see on that one that there is an opportunity potentially to get an IRA to a charitable remainder annuity trust and get a higher net to both the family and the charity if you look at those as a group. So there could be some options here. It'll take some math and some thinking on this, but it is something that might make sense for a charitably inclined beneficiary. I'm going to wind up here with a couple of things on life insurance. I think this is probably one of the more obscure ones, but it is a strategy being looked at for people. And a couple of the options here that you're looking at, one would be what we would call IRA relocation. This would be for someone likely in a situation where they have a taxable estate, certainly an income tax situation, where what you're going to do is take some distributions from your IRA, use those distributions to pay life insurance premiums that are held within an irrevocable life insurance trust. Upon your death, that life insurance policy that's in that trust will pay out, and that will be estate and income tax free. So that can be an advantage, especially again for someone who has a taxable estate. The other one would be the Roth conversion hedge, and this would be where the grandparents that are in their 60s and 70s are looking at planning for many years of Roth conversions at those lower rates that we talked about. However, one of them dies prematurely. What you would do is take out an insurance policy to hedge that. If they didn't get 10 or 20 years that they were hoping to convert, then they would actually move on and get it a little bit from the insurance policy here. So I'm going to wind up now. I know that we've just gone through quite a bit between Michigan and I on the strategies that may be involved here. Certainly want you to reach out to Lauren, Michigan, or me on these, and certainly we'll be available to talk about that later. I'm going to go ahead and release this now to, oh, there you go, Lauren.
Thank you, Dana. So I'm going to focus on the Secure Act, but from the estate planning perspective. And now my screen has frozen, so give me just one moment. There we go. All right, so what is the impact on estate planning? The first thing you want to remember when it comes to retirement assets is that they are one of the least desirable assets to inherit. If I have the opportunity to inherit a $1 million IRA or a $1 million checking account, I'm going to want to take the checking account, and here's why. When I take $1 out of that checking account, I don't have to report that dollar as income on my income tax return or pay any tax on it. The IRA, on the other hand, when I'm a beneficiary and I'm withdrawing funds from the inherited IRA, I need to report what has been withdrawn as income and pay tax on that. So in my world, we consider inheriting retirement accounts a income tax ticking time bomb. It's not a question of when it's going to go. It's not a question of if it's going to go off. It's when it's going to go off. Now, what Michigan and Dana have done a great job in describing, which I will continue to describe, is that what the Secure Act has done is change the way that beneficiaries are able to take out the inherited IRA proceeds. So back in the day, which was only a year ago, if I inherited an IRA from my mother, then I would have to take required minimum distributions, RMDs, and those RMDs would be calculated based on my life expectancy. So the younger the beneficiary, the smaller the RMDs. That way I can draw that tax deferral out throughout my lifetime. Under the Secure Act, there are still beneficiaries who will get that lifetime stretch. However, the majority of beneficiaries now are subject to this 10-year rule. So going back to the IRA I inherit from my mother, instead of me being able to take it over my life expectancy, I now have to withdraw all of the account assets within essentially a 10-year period. So I no longer get that maximum tax deferral. Keep in mind that the Secure Act is new legislation. It just passed. We still need regulations and guidance from Treasury. Now, of course, that doesn't mean that there isn't action you should be taking right now, rather that this is not the last you're going to hear of the Secure Act. So now let's go to a polling question. And our polling question is, have you spoken to your estate planning attorney regarding the Secure Act? And it's yes or no. So far, it seems like the majority have not yet spoken to their attorney, and that's okay, because I promise you today, I'm going to arm you with things to discuss with your attorney. So let's end the poll and talk about what do we need to do given the Secure Act with our estate planning. The first point is not everyone will need to update their estate planning documents. If the majority of your assets are not in retirement accounts, or you don't even have a retirement account, you may not be concerned about the Secure Act whatsoever. The other thing to consider is who have you named as a beneficiary? If you've named an individual or a charity, so essentially you haven't named a trust. then maybe you won't be making any changes whatsoever. The best person to speak to about whether or not you need to make any changes from an estate planning perspective is your attorney. Your attorney is going to know your plan because, after all, the attorney drafted the plan, and will be able to go through with you whether any changes need to be made. And maybe it won't be any amendments to your actual documents. Maybe, if anything, you may change a beneficiary here or there, depending upon what your current goals are and if the Secure Act has any sort of impact whatsoever on your planning. So the way that we figure out if which category is going to apply, so if we get that stretch or if we get that 10-year rule, is we need to first figure out what category the beneficiary falls in. Now, this is determined at the account owner's death. And there are 3 different categories of beneficiaries. There's the eligible designated beneficiary, the designated beneficiary, and the non-designated beneficiary. So let's start with the eligible designated beneficiary. This is the brand new category under the Secure Act. When you see this category, you want to think of stretch IRA is still possible. That is what this category means, at least for the most part. So a surviving spouse is considered an eligible designated beneficiary. An owner's minor child until majority is considered an eligible designated beneficiary. What is of critical importance is that it's the owner's minor child. It's not somebody else's minor child. So if I name my nephew Miles, who is age 8, as the beneficiary of my 401k plan, he's not going to be able to get this stretch treatment. Other eligible designated beneficiaries include disabled individuals, chronically ill individuals, individuals who are not more than 10 years younger than the account owner. This would also include somebody older than the account owner would qualify for this treatment. And finally, any see-through trust that has the beneficiary as who is an eligible designated beneficiary. We will get back to eligible designated beneficiaries and see-through trust treatment shortly. The designated beneficiary, on the other hand, is the one who is subject to that 10-year rule. So who is a designated beneficiary? Essentially, anybody who we haven't named in the previous slide, who is a person, is considered this designated beneficiary, and as well as any see-through trust for such person. That person or that trust is going to be subject to that 10-year rule. And then the final category is non-designated beneficiaries. Now, this category was around before the Secure Act. It is still with us. We are not going to focus on it, but examples would be if you named a charity or you named an estate. Those are examples of non-designated beneficiaries. So let's look into this income tax deferral treatment. As I mentioned previously, that eligible designated beneficiary gets to use that lifetime stretch for the most part. Where there is a quirk is when it comes to the minor child. The quirk is the minor child doesn't get that stretch for the remainder of that child's lifetime. Rather, that stretch ends upon the child attaining the age of majority. Now, previously I mentioned that we are still in need of guidance and regulations from Treasury. One of the things that we need guidance on is what exactly does the age of majority mean? It could, for example, be keyed to the state's age of majority, which could be 18 or 21, depending upon where you live. Or it could be keyed to a completely different regulation in the code, which has the age of majority at age 26. Whatever the case is, once that child hits that age, we no longer have that stretch available, and instead, that child is going to be subject to the 10-year rule. Now, the designated beneficiary, that is the one that's going to have that 10-year rule. And what that means is that over the 10-year period, that beneficiary is going to have to withdraw all of the funds from that account. Now, there is not an RMD associated with the designated beneficiary under this 10-year rule. So the beneficiary could take it all out in the first year. The beneficiary could divide it over the 10 years, or the beneficiary could wait until the end of the 10-year period to take it all out. What's important to remember is that once the money comes out of the account, it is going to be subject to income tax. Now, in the interest of time, I'm going to skip over the non-designated beneficiary, but the information is there for you on the slides if you want to go back and look at it. So let's move on to another polling question. The question is, have you named a trust as the beneficiary of your retirement plan? And the answers are yes or no. So it looks like we've got most folks, it seems right now, who haven't been naming a trust as the beneficiary. Now, by the way, that doesn't mean you shouldn't be paying attention to the rest of the presentation. You'll still want to pay attention. And actually, let's end the poll right now. So it looks like the majority have not named a trust as the beneficiary. But let's talk for a second about the trust, because they are of critical importance under the Secure Act. So I have mentioned throughout the presentation something called see-through trusts. And those are simply trusts that are or have been ignored when determining required minimum distributions. So a trust is not a person. It doesn't have a life expectancy. But what us estate planning attorneys have been able to do is use the beneficiary's life expectancy. So we see through the trust to figure out who the beneficiary is and use that beneficiary's life expectancy when calculating those RMDs. Now, there are two types of see-through trusts. We have conduit trusts and accumulation trusts. A conduit trust means that when the trustee receives that RMD, the RMD must immediately go from the trustee to the beneficiary. Accumulation trusts, on the other hand, means that when the trustee receives that required minimum distribution, the trustee is not required to automatically send it to the beneficiary. For example, the trustee may decide to hold on to it, add it to principal, continue to invest it, and then distribute the funds whenever the trustee deems appropriate. Keep in mind that the Secure Act does not get rid of see-through trusts. See-through trusts still work under Secure. What you may not like, though, is the results of what's going to happen with your see-through trust, especially if you have a conduit trust and your beneficiary is subject to that 10-year rule. Now, by the way, how you are able to figure out if you have a conduit trust or an accumulation trust, your drafting attorney who did the estate planning documents will be able to tell you that right away. So let's talk about trust planning under the old law. So under the old law, pretty much everybody was eligible for the stretch IRA, which meant that we used the trust beneficiary's life expectancy for figuring out those RMDs. Now, the reason it worked so well previously is because most of the beneficiaries were far younger, and the amount that was coming out, that RMD, was minimal because we had a whole lifetime of RMD. So the fact that the trustee had to turn around and push that RMD out to the beneficiary really wasn't that big of a deal because the amount wasn't as big as we're going to see it's about to be. So under the new law, designated beneficiaries no longer get that stretch. So here's what happens. If you have a designated beneficiary, which a lot of beneficiaries will be, they're now subject to that 10-year rule. If we have a trust that's a conduit trust and it is subject to this 10-year rule, that entire retirement account will need to pass from the trustee directly to the beneficiary in a matter of 10 years. Now, most of us estate planning attorneys who draft trusts for clients do it because the beneficiary really needs a trust. Maybe the beneficiary isn't good with money, maybe they have creditor issues, maybe they work in the type of profession where they could get sued quite frequently. In that case, we are not doing this beneficiary any favors by passing out the amount that's being withdrawn from the IRA, the inherited IRA, which must be taken out over 10 years, and giving that directly to the beneficiary. So if you do have a trust that is a beneficiary of a retirement account, you want to sit down with your attorney to figure out, are we working with a conduit trust? What the results look like, and maybe we want to make some changes, whether we convert it to an accumulation trust, so that way the proceeds don't have to immediately go out to the beneficiary, or maybe, depending upon how long it's been since you did your estate planning, you may decide that, gosh, I don't need a trust anymore. My kids are old enough. Let's give everything to them outright. I have been focusing primarily on planning, but I want to take a second to cover trust administration issues under the Secure Act. So anytime I have a client that's serving as trustee, I'm always quick to tell them about the potential fiduciary liability. And under the Secure Act, I think that the fiduciary liability is going to be even more critical. With this 10-year rule, we do have a situation where there is going to be large tax bills, because all of a sudden an account that we were hoping of stretching out for decades upon decades needs to be emptied within 10 years. And on top of that, we're probably going to have some beneficiaries not too excited about the tax bill, or not too excited that there is far less left in the account because of the tax bill. I cannot stress enough that if you find yourself serving as a trustee of a trust that has an inherited IRA account in it, it is critical that you work with your accountant, your estate planning attorney, and your financial advisor. Not that the estate planning attorney isn't important, but the financial advisor and the accountant can do financial and tax modeling for you. So the fiduciary can start planning for this income tax event or various income tax events that are going to occur if the 10-year rule is at play. So to wrap this up, what are the planning solutions? Keep in mind that with just like any estate plan, it's not one size fits all. Estate planning attorneys will tell you they do not fill in blanks, and I promise you we definitely do not fill in blanks when it comes to the Secure Act. So it's most important to sit down with your advisors, and that includes the Mishkins and the Danas of the world, along with your estate planning attorney, to figure out, are your intentions the same as they were when you originally completed the beneficiary designation forms and your estate planning? And if not, what are the ways to combat those changes? You may find that you're not making any changes to your documents whatsoever. You may instead be taking advantage of the Roth conversions or life insurance options, items that Dana spoke about previously. But whatever the case, I can't stress enough how important it is to approach this as a team. And with that, I will send it back over to Mishkin for Q&A.
Okay, well, thank you very much, Lauren. That was very, very informative. Thank you, Dana, that you did a great job as well. I know I learned a lot. Let's take a look at the Q&A questions And I think we have a couple that are super specific here, but maybe we can kind of back it up a little bit. So one of the first ones we have was, how does a Roth conversion work? I have a 403B plan. Dana, Lauren, do you guys want to chime in on that? Maybe give some guidance?
Sure, it's Dana. I'm happy to chime in on that. I talked a little about that very briefly, but essentially to do a Roth conversion from a 403B plan, you're likely going to have to first roll that to a regular IRA. And then from that point, you would do the conversion from the regular IRA to the Roth IRA. So probably a two-step process. There's not going to be, most 403B plans are not going to have any provision to do that. So it's a two-step process there.
Right. And, you know, I work with a lot of clients that are considering giving up their green cards, and they're looking at the net worth test. And one of the things we do is we'll do the Roth IRA conversions, because we know that when they convert from a U.S. taxpayer to a non-resident alien, it's better for them to hold the Roth IRA than it is to have the 401k or traditional IRA. So there's a lot of planning techniques that you can use for the Roth conversion. Okay, next question, and I'll kind of field this one. The question is, in regards to Revenue Procedure 2020-17, if a foreign pension is exempt from filing trusts, Forms 3520 and 3520A, are the contributions and earnings still taxable in the income tax return? That is a very astute question. Basically, what the question is saying is, if the foreign pension qualifies under the safe harbor of 5.03, and you're no longer required to file the foreign grantor trust forms, in essence, you're not having a pass-through entity, does the income still pass through the individual return? I have that same exact question for the IRS. It doesn't tell me exactly how they want to treat the income. They're very silent on that. So that's one of the comments that I have for them. And then furthermore, how do we look at that going backwards, especially because you have PFIC rules that apply and all sorts of other tie-ins to the tax return that I don't think were considered when this Rev Proc was given out. So that's a great question, and I will tell you that to be continued. We will definitely answer that at a later date. Okay, let's go to another question. And this one's a very basic one, and I'll toss this one up to Dana or to Lauren. I have a daughter that inherited an IRA in, say, a previous year, and she's never drawn anything down. What are the rules with taking drawdowns from an inherited IRAs prior to the Secure Act?
Sure, I'll take that one. I mean, great question. And interestingly enough, certainly she should have been taking distributions from that IRA for many years now. And it's a tough one too, because there is actually a 50% penalty for amounts that are not drawn, that are required to be drawn out of that inherited IRA. So if that depends on how substantial that amount is, if that is a substantial account that has grown, then you may need to talk to your tax accountant or even a tax attorney as to what type of plan you want to come up with to go back for many years there and figure out what to do to rectify that situation, that these required distributions have not been taken out for almost 30 years there, it looks like. So I would definitely recommend that you go back to, again, your CPA and or tax attorney. And if it's a substantial amount there, then you could have a complicated answer there on how to try and get some kind of reprieve from the IRS on going back and making these distributions.
Yeah, and I'll add that in situations like that, I've seen that before. I've seen the multiple beneficiaries where people haven't been taking it based on the proper age of the oldest beneficiary. I mean, there's all sorts of moving parts to those kind of situations. But for that particular circumstance, if we just think about it generally, I like the domestic voluntary disclosure program. I think that, they can come up with some creative solutions. Because again, you talk about 30 years of non-compliance and non-payment. I don't know if the IRS would make you go back to 1992 or whatever year that is to file amended tax returns. I think that'd be a little extreme. So I think you'd probably come up with kind of a middle ground, maybe file 3 years of returns, maybe move the plan over, some kind of iteration like that, pay a penalty of some sort. But that's something that definitely should be considered. Okay, let's go on to another one. Under the Secure Act, what are the RMD requirements for an inherited IRA? Dana, Lauren, any of you guys want to take that one?
Sure, I'll take it. So the difference with the Roth is that we don't have to worry about tax that hasn't yet been paid on it. So the requirements are still going to be the same. You could have a Roth that's subject to the 10-year rule. The great news is that when it's coming out, we don't have to worry about taxes on it because it's already been paid.
Great. Okay, next question. What are the Secure Act implications for foreign pensions, i.e. World Bank and IMF? That's a fantastic question. I love that question because if you think about what the Secure Act has done for a lot of the 401k plans in regards to annuities, they're basically coming in alignment with the way that the World Bank IMF plans are already set up under 401a. And so really there are no changes to those World Bank IMF plans. More what has occurred is that other U.S. plans have come into alignment with how those plans are already structured and put into place. So again, I think you're seeing a harmonization, if you will, of U.S. retirement plans, foreign retirement plans that are classified as qualified U.S. retirement plans. So I think you're seeing a lot of that harmonization going on by the IRS. They're trying their best to do what Congress should have done a long time ago. That's probably the easiest way that I can put that. Okay, let's go on. Let's do another one. Am I right in assuming the speaker's use of the term IRA means only traditional IRAs? Are the rules different for Roth IRAs? I'll let Dana or Lauren jump in on that one.
Yeah, let me take that one just because I may have been the one that was guilty about not being as clear when I was speaking. But yes, I mean, in terms of traditional versus Roth IRAs, the rules are different, especially as was alluded to just a moment ago and explained that, for a Roth IRA, there's no taxation on those distributions. There are also no required distributions during the original owner's lifetime. So that can be advantageous. Now, when they do move down to the second generation, when they're inherited, for the Roths, there are required distributions, but in almost all cases, they should be tax-free. That different than a regular IRA, that those distributions are going to be taxed to either the owner of that IRA or to the beneficiary. It doesn't really matter. That income tax burden does carry on from the owner to the beneficiary, and somebody is going to pay the taxation on those IRA funds over the years when that account is paid out. So hopefully that clarifies. I don't know if anybody, Lauren or Michigan, want to add on to that.
I'll add by answering this next question. It says, can you say more about Roth versus retirement plans if you have beneficiaries abroad? So just to follow up on what Dana was talking about, you want the Roth IRA because it's not going to be taxable. Now, a lot of times what we see is when you have a beneficiary abroad that's a non-U.S. person, strangely enough, whoever's holding the IRA, whoever's managing the IRA still wants to withhold 30% on the Roth distributions to a non-U.S. person. And then you have to claim that back from the IRS, which can take 18 months to get back a refund. So I like the Roth IRA because it's just a stronger position to take on the tax return as opposed to a traditional IRA. And I think that, it could be worth looking at someone that's older that maybe has offshore beneficiaries, maybe making some of those conversions from traditional to Roth, over the next couple of years. Okay, next question. Are capital gains tax payable when doing a Roth conversion? If so, is the current period of depressed market values a good time to do a Roth conversion? Dana, Lauren, you guys want to jump in on that one?
Lauren, you have any interest in fielding that, or should I?
Since you do Roth conversions and I do not, I would recommend that you answer that one.
Sure. No, it's a good question. And when you're doing Roth conversions, when you're taking any type of distributions from a retirement account, an IRA, or most other qualified plans, that income that comes out is all going to be ordinary income. There is not any opportunity to take capital gains out of one of those accounts, even if you may have grown that account over the years by creating great capital gains, buying Apple stock or something like that that appreciated tremendously. So any income coming out of an IRA to be used for a Roth conversion is going to be ordinary income, and that ties back into those tax bracket charts that I went over, that we're talking about the ordinary income tax rates, and you want to focus on those and where you think your rates will be if you're looking at Roth conversions, and try and keep those in more the middle and lower brackets rather than hopefully in those upper brackets in most cases.
Okay, I think we're going to take one more question, and then I know we're running up on our time limit here for the presenters. We need to get them back to work, back to doing the planning and all those things, monitoring the markets to make sure everyone's doing well. So the last one, which I can partially answer, but happy to give to Lauren if she's got the background on this one, are what are the tax consequences of beneficiaries of World Bank and IMF pensions? Should a trust be designated as beneficiary? Lauren, do you want to try to field that one, or do you want me to opine on it?
So let me just say something about the trust, and then you can go into the tax consequences.
Sure.
When it comes to naming a trust as a beneficiary of anything, including a pension, you really want to think about, why in the world am I naming a trust? If you have concerns about the beneficiary, whether it's because of how they're going to spend it or creditor protection concerns, then a trust is an excellent option. One of the things to consider whenever you're doing planning is, just because the tax implications may not be ideal, if we are more concerned about the person that's going to be benefiting, if we're going to hurt that person, then perhaps even if there is a negative tax implication, we really should be looking to a trust type of model, because in this, we're trying to protect our beneficiaries at the end of the day. And Michigan, I'll let you take the tax implication question.
Yeah, so I think that there are a lot of questions that come out of that one question. Typically when we do pre-retirement planning for individuals that have worked at the World Bank or the IMF, there's a whole host of statuses that to consider, from the G4 to the U.S. citizen. And, we have to talk about the commutation, taking the annuity, long-term, short-term strategies. I definitely think that having the trust as a beneficiary can be useful for some situations, but I think you have to look at all the different, and I think as Lauren said, it's not just the income tax consequences. I think there's a whole host of other things to think about, from how much money do I need to live off when I retire? Do I have someone that is maybe disabled or elderly that needs significant care, so I need more money up front? How do I want the trust to maybe take over some of the burden on that? So I definitely think it could be a good solution. It just depends on the facts and circumstances. And, that's where the pre-retirement planning is super powerful, and doing that not only from an income tax perspective, but also doing that from kind of an estate planning holistic perspective. And that's where I think having, myself, Dana, and Lauren all together and providing guidance in one big unified package can be very valuable. So that's it for today. We really appreciate everybody showing up. We hope everyone found this useful and beneficial. And we thank you for your attendance. And we thank Dana and Lauren for being presenters. Thank you guys very much.